Hi, my name is Arul George Skaria and I am a faculty at the National Law University, Delhi. So the module which we will discuss in this presentation is titled Ambush Marketing. So let me briefly introduce the outline of this lecture. We will be seeing what is ambush marketing, who are affected by ambush marketing, what are the traditional legal measures taken against ambush marketing and how effective are they. We will also see what are the current legal trends in the area, and we will also see whether some of the current legal measures violate the important fundamental rights. Let's first see what is ambush marketing. Ambush marketing is a marketing strategy wherein non-sponsors associate themselves with a sponsored event to give an impression of association with the event without formally associating with that event and committing to the financial liabilities involved in it. In other words, ambush marketing can be considered as unexpected interventions from certain companies to create an impression upon spectators or customers that they are associated with an event. So some people call ambush marketers as an uninvited guests to a sponsored event. Let's understand the concept through an example. I hope every one of you knows about Olympics. International Olympics Committee, which is a non-governmental, non-profit organization, owns all the rights relating to the Olympic symbol, Olympic flag, Olympic motto and the Olympic anthem. And IOC has the right to decide the sponsors of the Olympic Games, and only those sponsors are allowed to use those symbols. But as we could see from past many incidents, there have been instances where the corporate rivals of those sponsors will be dispatching hundreds of spectators wearing t-shirts and caps with the company logos to stadiums. Sometimes they can also place billboards with the ambush marketer's name and logo adjacent to the site of the event. And in certain instances, it is also seen that the corporate rivalries may supply to the crowds paper flags with the company logo. And in some cases, there have been instances wherein publicity contests were organized and tickets were offered to the event or given prizes. Let's take a more recent example, again something which you all know, FIFA World Cup. FIFA has three-tier sponsorship system. The highest level is known as FIFA partners, who have the highest level of association with FIFA and all the FIFA events. So if you look at the last World Cup, you can see that the 6 major FIFA partners were Adidas, Coca-Cola, Emirates, Hyundai, Sony and Visa. The second tier of sponsorship is known as FIFA World Cup sponsors, and they associate with FIFA Confederations Cup and FIFA World Cup on a global basis. And in the last World Cup, we could see Budweiser, Castrol, Continental, Johnson & Johnson, McDonald's, Moipak, OE and English Solar associating themselves with the FIFA as World Cup sponsors. It is estimated that the FIFA partners paid around 25 to 50 million per year to become the FIFA partners. And the FIFA World Cup sponsors, it is estimated that each of them paid around 10 to 15 million per year. And now FIFA is even planning to have a third tier known as regional supporters. But why are all these corporate firms trying to associate themselves with the event like World Cup? As you must be knowing, the viewership estimate is immense. So there are around 3.2 billion people who have watched World Cup, the last World Cup in Brazil. And this turns out to be around 770 billion minutes of attention. And this is a huge marketing opportunity for brands. And no wonder the vast majority of revenue for FIFA comes from television and marketing rights. Interestingly, About the last Brazil World Cup, it is reported that 5 of the top 11 most shared online football advertisements were from those who were not FIFA partners or FIFA World Cup sponsors. One interesting example which I would like to provide here is a Nike Risk Everything campaign which featured well-known football players without any direct references to World Cup or FIFA. I have provided here the YouTube link to the video and I would strongly recommend all of you to watch it. Similar was a campaign done by the headphones manufacturer Beats, who used players like Neymar to promote its headphones during the FIFA World Cup. Important to note here that both of them were not FIFA sponsors, but they could actually gather far more audience than most of the sponsors. Just look at the number of people who have viewed the videos in YouTube alone. It is also important to mention here briefly why sponsorships are important. Though it is a purely marketing concept, sponsorship needs discussion in the context of this module, as ambush marketing occurs in the context of sponsorship of events. And the sponsorship is a form of marketing whereby a sponsor contributes to or underwrites the cost of staging an event or the cost of a participant in a prestigious event or the cost of an individual or a team under a periodic agreement in return for grant of marketing and promotion rights by the sponsored party. And sponsorship provides an opportunity for the sponsor to promote the image of her or his products through an association with the event or individuals concerned. Even though the range of activities and events that receive sponsorship are wide, it is important to note here that cultural and sports events are the ones that are the primary beneficiaries of sponsorship, and this is due to their high popularity and public appeal. Between the cultural and sports events, sports score a higher position in sponsorship as a result of potential worldwide audience for the games. And a successful sponsor is the one who becomes synonymous with the event. And today almost all the sporting events across the world depends on sponsorship. In general, sponsorship accounts for around 35% of the revenues of most events. But because of ambush marketing, certain companies are able to capitalize on the goodwill, reputation and popularity of a particular event by creating an association with the event without any authorization or payment of sponsorship fees. Now let's ask, who are the stakeholders who are affected by ambush marketing? As you can imagine, the most important group is the sponsors. Ambush marketing damages the exclusivity rights associated with sponsorship. And corporate sponsors will be involving in sponsorship only if they are assured of exclusivity. And when that exclusivity is lost, the value of sponsorship is also lost. Event organizers are also equally affected by ambush marketing because, as I mentioned earlier, sponsorship is one of the most important sources of revenue for event organizers across the world. And in some instances, if ambush marketing is prevalent to a very great extent, they may even be forced to return the sponsorship money. Moreover, if ambush marketing is happening consistently, it may even reduce the sponsorship value of events in future. So we need to ask ourselves, will it be possible to conduct massive events like World Cup or Olympics in the absence of sponsorship? Finally, it is also important to note that at least some section of sports fans or consumers are also affected by ambush marketing, because at least in some instances it is leading to clear case of deceptions. As some of the surveys have indicated, consumers are also sensitive to activities involving Olympic related logos, even though the consumer attitudes are found to differ with gender and age. For example, women are seen as more sensitive to dishonest aspects of ambush marketing. Similarly, young consumers in the age group of 18 to 39 are considered to view ambush marketing activities as dishonest, misleading and unethical when compared to other age groups. So in this background, two important things which we would like to ask is whether ambush marketing results in violation of intellectual property rights associated with the event, and secondly and more importantly, what are the legal measures available against ambush marketing. So from the perspective of intellectual property rights, ambush marketing is a transgression on the intellectual property rights associated with an event. Even when the ambush marketers are not making any direct references to the protected intellectual property rights, they may be transgressing those intellectual property rights indirectly. But we need to ask ourselves, what are the measures available for addressing ambush marketing? And more importantly, whether traditional remedies like trademark infringement action or passing of action or copyright infringement action can resolve this issue. Let's look at them one by one. So the first one is trademark infringement action. As you may be knowing, most of the times event organizers register the event related logos and marks at the national trademark registries in different classes of goods or services to cover a wide range of goods and services. For example, before FIFA World Cup 2018, FIFA will be attempting to register FIFA World Cup 2018, 2018 games, etc. in different national registries. But whether the registration becomes successful or not is something that will be depending on national laws and the practices followed by different national trademark registries. A trademark will be infringed when a person other than a registered proprietor or a permitted user uses a mark which is identical with or deceptively similar to that of a registered trademark in the course of trade. When we analyze this condition in detail, we see that the mark used should be either identical or deceptively similar to the registered mark. The goods or services in respect of which it is used must be specifically covered by the registration. The use must be in the course of trade in the areas covered by registration. The use must be in such a manner as to reflect its use as a trademark. And finally, the defendant should not have been a permitted user. And a person is considered to have used a registered trademark when she or he affixes the mark to goods or packaging thereof, offers the goods for sale, market or stock or supply services under the registered mark, imports or exports the goods under the mark, or uses the registered trademark on business papers or in advertising. In situations wherein an identical mark is used in relation to similar goods or services, or where a similar mark is used in relation to identical or similar goods or services, there will be infringement if such use is likely to cause confusion among the public or is likely to create an association with the registered mark. In the case of identical marks on identical goods or services, there is no need to prove confusion, as there will be a presumption that it is likely to cause confusion to the public. Two important cases which I don't want to discuss in detail here because it will be discussed in your other modules, which can be very useful in the infringement analysis are the piano twist application case and the British sugar case. So please do refer to them also. The trademark infringement action can be used against ambush marketing under certain situations. For example, if ICC has been successful in registering Cricket World Cup as a trademark in respect of certain goods and services in a country, and if someone uses that mark on class of products or services for which ICC has obtained registration, ICC can then approach the court on grounds of trademark infringement. But in such a hypothetical situation, the success of infringement action depends on 1. The registration of the mark, 2. The use should be use of identical or similar marks by the defendant, and the use in respect of the same class of goods and services for which ICC had obtained registration. One of the interesting cases which shows the usefulness of trademark infringement action is Boston Athletic Association versus Mark Sullivan. So in this case, the organizers of Boston Marathon, an annual event, approached the court to enjoin the defendant from manufacture and sale of t-shirts and other wearing apparel with the marks BA BA Marathon, Boston Marathon, and its unicorn logo. The main argument of the defendant was that Boston Marathon had become a generic term. However, the court ruled in favor of the plaintiff and enjoined the defendant from infringing the service marks of the plaintiff. Some of the marks may also get additional protection as well-known marks. The advantage of getting protection as a well-known mark is that the protection will extend to dissimilar goods or services. So for example, if ICC Cricket World Cup can be proved as a mark with reputation in India, ICC will be able to prevent the use of its mark on any goods or services irrespective of the classes in which ICC already has registration. But now we should also know what are the limitations of trademark infringement action. The most important limitation is that ambush marketers often do not use or display registered marks of the event. They instead create a false association with the marks through their ingenious methods. The best example to illustrate here is a advertisement strategy used by American Express during the Barcelona Olympics. So the slogan which they used is, "And remember, to visit Spain, you don't need a visa." As you can clearly see here, they didn't use any of the marks associated with the event or their corporate rival. But at the same time, they ambushed the event organizer and the sponsor in a clear way. It is also important to note here that trademark infringement action will be of little or no help in most of the common ambush marketing practices like buying commercial time during the telecast of events, making independent contracts with athletes and teams, throwing parties and other events in the host cities before, during or after the event, buying advertisement spaces in and around the event place, and even making people wear apparels with the ambusher's mark and carry products, signs or accessories bearing the ambusher's mark to the event place. Finally, it is also important to note that proving the likelihood of confusion, which is a necessary ingredient in most infringement actions, is difficult in most instances of ambush marketing. Another major issue in many countries like India is that the title of events like World Cup may be considered by the trademark registry or the courts as generic words and hence not capable of registration. For example, in the famous case of ICC Development International Limited versus RV Enterprises and another, the court was clearly mentioning that World Cup is a dictionary word having the meaning a tournament or event where several nations participate. Court considered it as a generic term which is not capable of conferring any exclusive rights for the event organizers. Now let's have a look at the effectiveness of copyright infringement action. As you might be knowing, copyright protection also exists in different areas relating to an event. For example, the logo created by the organizers of the event can be protected as an artistic work. Or alternately, various literatures relating to the event, like the official document that provides details about time, venue, etc., also attains copyright protection provided it satisfies the minimum requirements for obtaining copyright. An important feature of copyright is that there are no requirements to go for registration of the work to achieve protection. Copyright infringement happens when a person other than the copyright owner reproduces or imitates any of those copyrighted materials relating to the event. Some of the important factors to be considered while determining a question of infringement are whether the plaintiff is the owner of the work, whether the defendant has carried out any activities falling within the domain of the copyright owner's rights associated with copyright law, whether the defendant's work was derived from the copyrighted work, and whether the defendant has copied all or substantial portion of the copyrighted work. In the context of ambush marketing, copyright infringement action can be helpful in cases where the ambush marketers copies the logos associated with an event. Because, as I mentioned earlier, logos can be protected as artistic works and reproduction of such logos in any medium will result in its infringement. One of the important cases which I would like to mention in this context is ICC Development International Limited versus Evergreen Service Station and another. In this case, the defendant used the logo of the plaintiff during its promotion campaign. Delhi High Court held that the logo denoting black and white stripes of zebra was an artistic work within the meaning of copyright law and hence subject to copyright protection. As a result, the defendant was restrained from using the logo of the plaintiff in its advertisements. But it needs to be noted here that even though the court upheld the argument of copyright infringement, the larger question of violation of the rights of the plaintiff through ambush marketing was rejected by the court in this case. The only restraint imposed by the court was the use of the logo of the plaintiff. We must also know the limitations of copyright infringement action in the context of ambush marketing, and most of the reasons that fails a trademark infringement action are likely to fail the copyright infringement actions also. For example, most of the ambush marketers do not use or display logos or other copyrighted materials relating to the event directly, and they normally create a false association with the marks through their ingenious methods. And it is very difficult to bring them within the parameters of a copyright infringement action. And the same American Express advertisement example I mentioned in the context of trademark law will be equally applicable here also. And if the matter is going to the court as a copyright infringement action, it is very unlikely that the court will be saying there is a copyright infringement in that advertisement law. The third traditional legal measure which I would like to mention is the action for passing off. As most of you might be knowing, action for passing off is a common law remedy and it is widely used in the fight against ambush marketing. In most simple words, an action for passing off is allowing trader A to prevent a competitor B from passing off their goods as if they were A's goods. The three essential elements for a successful passing off action are: 1. Reputation or goodwill; 2. Misrepresentation; 3. Damage as a result of such misrepresentation. Is it easy to prove this in the context of ambush marketing? I would say the first and third are comparatively easy, but the second factor is extremely difficult. One of the interesting cases which can illustrate the effectiveness of or the limitation of passing off action in the context of ambush marketing is ICC Development International Limited versus RV Enterprises. In this case, the defendant RV Enterprises was one of the authorized dealers of Philips, and they created advertisements before the World Cup Cricket 2003 using slogans Philips Diwali Manavo World Cup Jao and buy a Philips audio system, win a ticket to the World Cup. They also inserted a pictorial representation of a ticket with an imaginative seat and gate number saying Cricket World Cup 2003. Advertisement was shown in all media, including newspapers, television, internet and magazines. As they were not official sponsors and not entitled to distribute tickets, the plaintiff approached the court. The main argument of the plaintiff was that the defendant's intentional use of the slogans in question and the insertion of the pictorial representation of the ticket with an imaginative seat and gate number on the advertising campaign amounted to passing off and ambush marketing, as it was to create an identification with the event and to sell off their goods through that misrepresentation. The plaintiff focused its arguments on the real likelihood of confusion and the unmistakable aura of deception. Even though the court accepted that the law relating to passing off has been developing and expanding, it pointed out that this was a type of passing off claim wherein it is alleged that the defendant has promoted his product or business in such a way as to create a false impression that his product or business is in some way approved, authorized or endorsed by the plaintiff, or that there is some business connection between them. According to the court, the main question to be answered in such a situation was whether sufficient number of purchasers of the defendant's goods are unmistakably likely to be confused about the source of defendant's good or assume that defendants have some connection with the official sponsors of the event. The court observed that in the instant case, the defendants have not used plaintiff's logo or the masked dazzler on any of their advertisements or promotional campaigns. It also noted that the defendants have inserted only a pictorial representation of a ticket with an imaginative seat and gate number, so as to draw attention of the purchasing public to the event. The court was of the view that This did not show any likelihood of confusion in public mind that the defense are sponsors or licensees of the event. According to the court, the slogans merely showed that the purchasers of the defense good may win a ticket and travel package to see the World Cup and nothing more. Therefore, the court came to the conclusion that the basic ingredients of passing of action was not made out in this case. Among the traditional legal measures, passing of action is the most powerful one and one of the most frequently used weapons. But as the case laws discussed here point out, even passing of action is highly limited in its scope when it comes to fighting ambush marketing. When we realize the limitations of passing of action along with the limitations of other traditional legal measures like trademark infringement action and copyright infringement action, we may reach at a disappointing observation that the traditional legal measures are having very limited scope in fighting the sophisticated ambush marketing methods. This forces us to search for better solutions for addressing ambush marketing incidents. One of the important legal innovations that have happened in this regard is drafting of event-specific laws aimed at preventing ambush marketing. Two examples in this regard are Sydney 2000 Games Indicia and Images Protection Act 1996 from Australia and the London Olympic Games and Paralympic Games Act 2006 from UK. Due to time limitations, let's just have a look at the first one. For the Sydney 2000 Games Indicia and Images Protection Act 1996, the main aim was regulation of the use of indicia and images associated with the Sydney 2000 Olympic Games and the Paralympic Games for commercial purpose. The main feature was it supplanted and augmented the existing intellectual property laws to protect a peculiar set of indicia. And its legislative history can be traced back to a parliamentary report entitled Cashing in on the Sydney Olympics, Protecting the Sydney Olympic Games from Ambush Marketing. The Sydney 2000 Games Act defined Sydney 2000 Games indicia in a very broad manner so as to protect phrases like Game City, Millennium Games, Sydney 2000 and the combination of the words game, number 2000 and the words 2000. The Act also protected words like Olympiad, Olympic and the phrases like share the spirit, summer games, etc. The Act also made two lists. List A contained the words Olympian and Olympics and List B contained the words bronze, games, gold, green, gold, medals, millennium, silver, spirit, etc. Any combination of the words in the List A with any word in List B was brought within the ambit of the meaning of Sydney 2000 Olympic Games indicia. The broad strategy was aimed at preventing the common ambush marketing practices of referring to the events in indirect ways. A similar strategy was adopted in the Act with respect to the images associated with the games also. This also invited criticism from certain scholars that the Act tightly controlled the linguistic and symbolic domain. It is also interesting to note that the circumstances where the Sydney 2000 Games indicia and images were considered to as being applied were clearly clarified in the Act, and I would strongly recommend you to go through this legislation. So by first defining what all things can constitute the Sydney 2000 Games indicia and images, and then proceeding by defining the circumstances that will be considered as application of the Sydney 2000 Games indicia and images, the Act made the Sydney 2000 Olympics a really challenging game for ambush marketers. The Act empowered the Sydney Organizing Committee for the 2000 Olympic Games and the Sydney Paralympic Olympic Organizing Committee to license a person to use all or any of the Sydney 2000 Games indicia and images for commercial purposes, and specifically required them to make any entry of such licenses in the register of license users. The pragmatic approach of the Australian legislature and the Olympic Committee is quite evident in the drafting of the remedies under this legislation. According to this legislation, when a person other than the SOCOG, SPOC or license user uses the Sydney 2000 Games indicia and images for commercial purposes, a prescribed court will be having the power to grant an injunction to restrain the person from such conduct. The Act also provided a very interesting remedy, that is corrective advertisements. On an application from SOCOG or SPOC, the prescribed court was empowered to make an order under its discretion requiring a person to publish advertisements by such means as the court thinks fit, at the person's own expense and interval specified in the order if the court was satisfied that she or he has used the Sydney 2000 Games indicia and images for commercial purpose without the required authorization. This provision was certainly an open threat to the ambush marketing experts across the world, as no company would prefer to go for a corrective advertisement, as series of corrective advertisements through different media could cause irreparable damages to their reputation and brand value. The enactment of a good legislation as such is never a solution to any problem, and only a proper enforcement of the provisions of such legislation can address the mischief against which legislation was drafted. Most of the academicians consider the anti-ambush marketing strategy at Sydney Olympics as a big success. But if one may observe closely, it could be seen that even the Sydney 2000 Act didn't achieve its aim of preventing ambush marketing completely. The best example in this regard is ambush marketing done by Qantas Airlines, which is mentioned in your module. Though the event-specific laws have been successful to a great extent in threatening the ambush marketers, I must also mention that they have brought in some serious public concerns. The most important one is that they place unnecessary and unjustifiable restrictions on symbols and words in public domain. Many of the words restricted are those that should be available in public domain, and everyone has a right to use those words freely. Freedom of speech and expression is one of the most important fundamental rights present in the constitutions across the world, and we need to ask whether many of the restrictions imposed by event-specific laws are constitutionally valid. Another important issue, if strictly enforced, is most of these event-specific legislations would limit the freedom of individual athletes to exploit their success. It would be an injustice on the athletes and their personal sponsors if they are prevented from cashing their glory at the moment of their greatest achievements and marketability. Yet another issue is the restrictions on the right of people to choose consumer products of their choice. When an event organizer forces a genuine spectator to drop at the entrance a non-sponsor's cola bottle or a t-shirt with the logo of a non-sponsor, serious questions about personal liberty and consumer choice arises. Moreover, it is also important to observe that over-restrictions can damage the spirit of events. For instance, during the last ICC Cricket World Cup, a number of cricket fans complained that the event organizers' anti-ambush marketing concerns had gone excessive, impairing the excitement and glory of the event. Consequently, today, the major challenge before the event organizers is to safeguard the genuine commercial interest without contravening the fundamental delights and vivacity of the very event. Let me conclude this brief presentation by adding that while event-specific laws have been successful to a great extent in controlling ambush marketing incidents, we need to have more debates that can identify more balanced solutions. It is very important to strike a balance between the legitimate rights of event organizers and sponsors on one side and the basic rights of the general public on the other. While we need to protect sponsorship values of the events so that we will have more and more events, we also need to give due importance to the basic human rights. Democratic values and larger public interests in a society cannot be overlooked while endeavoring to protect commercial interests, and we can achieve that only through more debates on the subject and more balanced solutions. I hope that by participating in this module, you will also be able to contribute to more debates and more balanced solutions in this area. Thank you.